So, in this module, we're certainly going to jump around a bit, okay? Some modules, like say SOF 6007, your Web Development Fundamentals, there was a beginning and you built on that, and there was a middle and there was an end, a bit like kind of a 3 or 4 course meal. This module is going to be a bit more like tapas, where you just kind of have a bit of this, and or the next day we might do a bit of something else, and the next week we might do a bit of something else. So we will hop around a bit. It's doing that all by itself. Freaky, freaky, freaky. Stop. Now, so I know we were talking about blogging, and we're not done with blogging by a long shot. There's some things I want to show you that you want to do with your blog, but I'll do that in the labs. So this topic is more talky, you listeny. So we'll do that today and the next day, and it may even take 3 classes worth. But as you gathered from this morning's class, we're not in a particular rush either, so there's no problem there. So what I'm going to talk about in this class and the next few classes is intellectual property, and some of the terms that we'll come across you'll be familiar with, but I often hear students using them slightly the wrong way and stuff. So you'll get some clarity about the difference between copyrights and patents and things like that. Okay? So, first thing we're going to talk about is copyright. Now, if you have any comments or anything or observations you want to throw in, that's fine too. Some people get very excited about copyright, and it comes to things like downloading music, and stuff like that. No. So copyright gives protection to an author that prevents others from making copies. I don't know how many times I've fixed that typo. From making copies of his work without permission. So if you author some work, no one else can copy it. You can stop people from making copies. You could see how in the era of the printing press, it was easy enough to enforce, because there might have been 20 or 150 printing presses in town, and you could make sure that they only printed stuff that they were authorized to print. Copyright has, or was certainly a very long time ago, was also a system that allowed the state to ensure that only things that were supposed to be published were published. So that a printing press had permission to print things. One of the reasons it's sort of the license was to ensure that authors got their due. But also you didn't want people printing pamphlets about how the government is bad and stuff. That wasn't allowed. So you have traditions then in the US where they're very strong on free press, because that state was formed, or in the formation of that state, there were some issues with that. Lately, even China and Russia have used copyright, or the cover of copyright, to stop people printing and distributing and stuff, but not with the I think the Russian government at one stage went into people's offices and confiscated all of their machines because they believed they had illegal copies of Windows. But the government of Russia had no particular interest in Microsoft making money. It was just a pretense for making life difficult for certain groups of people. So it's interesting that in the very, very early days of copyright and in modern times, there are parallels in how the concept can be abused by governments. But the main purpose of copyright is to make sure that authors get paid. So you can't take a copy of a Harry Potter book and print your own one and sell it on Patrick Street. Now you'd have a job to print it cheaper than the book printers can, but because that work belongs to J.K. Rowling, she wrote it and she gets to say who makes copies of it and who doesn't. Obviously, in the digital era, it's harder to enforce copyright. No. So for something to be worthy of copyright, it must be original. Now, the threshold for originality is fairly low. I mean, some people would argue that Harry Potter isn't that original. Certainly the first one or two, but that's neither here nor there. So they weren't written before. It must be non-functional, so it must be something, it must be a creative work. Do you know what I mean? Like, so a list of the classes we did, or my shopping list for when I go to Tesco. I mean, that's original and I wrote it, but it's a functional thing. It's not a creative work in any sense. And again, actually, the threshold for what's considered creative is fairly low. So even the contents of a database can be protected using copyright. And you might say, well, there wasn't much creativity went into that. A very important thing about copyright is that the work must be fixed in a tangible medium. So if you have an idea in your head, well, that's no good. And copyright doesn't protect the idea. It protects the expression of it. It protects the work. So if you have a great idea for a story and you write that story down, well, then it can be protected by copyright. If it's in your head, that's no good. Once the story is written, if someone writes the same story or a very similar story, then you could have some protection. So it must be in tangible form. And again, this has posed problems for courts. I mean, what's tangible? How tangible is an audio recording on a hard disk? Is a hard disk a tangible medium? Is a magnetic tape a tangible medium? And courts have largely decided yes. Just because you can't read it as a human doesn't mean it's not tangible. It can be expressed. You could print it out, for example. So one of the challenges that courts have faced, and all courts everywhere face really, is interpreting laws that may have been written 100 or 200 years ago to modern problems. In Ireland, most of the laws have been rewritten now at this stage. But when the Republic, or when the Free State was formed, and later the Republic, all of the laws that had been in force up to that point were still in force. And it's only in very recent times that we've sort of revisited the statute book, and laws from 1722 or whatever have been updated or repealed or whatever. So every 20, 30 years or so, most states have to update their copyright law a bit, because who could have foreseen 200 years ago MP3 players and Dropbox and Napster and LimeWire and things like that. Even things like video recorders posed problems. I mean, if you were taping stuff off the telly at home to watch later, well, that was breaking the law. So but most people would consider that reasonable. So how did the law adapt to accommodate those things? So some interesting challenges. There have been some interesting challenges, and there continue to be very interesting challenges for lawyers and judges and lawmakers. Not to mind individuals having to navigate all this. I mean, I don't own a DVD player. So if I buy a DVD and I want to watch it on my TV or my computer or my iPad, I have to break the law just to do that. but I think most people would consider what I'm doing to be quite reasonable. I did buy the thing after all. So some interesting challenges. The origins of copyright come from, printing books. So it's good to think of it, having those origins and what was meant at the time, and see how we can apply those. You cannot copyright an idea. I often hear students say, "That's my idea, I copyrighted that, man." And you can't copyright an idea. You can copyright an artistic work, an original artistic work in tangible form. So if you have a cool idea for a story, a cool idea for a movie, and you write it down in words, it's in tangible form then. Interestingly, you don't have to do anything to secure copyright. It subsists. Once the work is created, it's worthy of protection. You may get into some dispute with someone over who wrote it first, or who wrote and who copied from whom. But in terms of copyright, it exists once the work is created. So this quote here is from the World Intellectual Property Organization, who would probably be the people who would come banging on your door if you were up to, if you were a government allowing stuff to go on, they'd probably come banging on your door. So if you're the government of some makey-uppy country and you're allowing all sorts of file sharing stuff to be hosted in your particular country, the WIPO might come knocking on your door. So it's an industry body. So the purpose of copyright is to encourage a dynamic culture while returning value to creators so that they can lead a dignified economic existence and to provide widespread, affordable access to content for the public. So the argument is, and it's a simple one, it's a seductive one, there are some flaws with it, but the argument is that, let's say you're a musician or a writer. If you produce some creative work, you deserve to make some money off that so that you can carry on creating productive works, creative works. So let's imagine, and it'll be quite a stretch, that I am in fact Ireland's greatest rapper. Okay? But, I have a mortgage, I mean, if I could record some tracks and put them out there and make money from them, maybe I could give up this lark, and become a rock star. I don't even want too much fame, do you know what I mean? I wouldn't want to be, Eminem famous, just like, be able to pay my mortgage, go to Mahon Point and be able to afford to, buy food in the cinema from time to time. Do nice things, I don't want to be mega rich, but, it'd be nice to make a living from being a rapper instead of doing this. And the argument is, but if I can't make money from that, then I'd have to stay lecturing. And you'll all lose out because you won't get, to hear me. So that's the deal that copyright allows artists to make with society. So you produce work, we'll set up the rules that you get some money from it, and then you can keep creating things. We'll have the pleasure of those, and we'll use copyright to make sure that you get some money. Now, there are arguments, though, that copyright has gone too far and that it no longer serves the original purpose it was meant to. And you get all sorts of justifications as well. I mean, you often hear people say, well, I don't steal music from any poor people. I mean, it's certainly the case that Amy Winehouse didn't need any more money. I mean, if she had a little less money even, she might be with us today, still singing. So there are some issues. Okay? But that's the general deal. It's kind of a contract that society makes with creative people. You keep creating, we set up a system so you can get paid. Now you may argue that, you know, oh, there's so much crap music out there anyway, the system isn't working, you know, things like that. But I mean, I think everyone has 5 or 6 albums, however they came by them, that they would say to themselves, well, do you know what? That's feckin' brilliant. The person that made that, you know, deserves a tenner from me. Now maybe they don't deserve 30, you know, I mean, 30 euros a lot for a CD. The prices were going up there for a while there. They were pushing 25 euro like at one stage. They're a bit sensible now again. But everybody has some music in their collection that they think, you know what, that's brilliant. That person really deserves a few bob for that. No. So copyright holders have some exclusive rights then. So they have the exclusive right to make copies of their work. They have the exclusive right to produce derivative works. So if I write if I wrote Harry Potter, I get to say who can make the movie of it. Do you know what I mean? You can't just make a movie of my book. Okay, the movie is completely different from the book. I didn't write the movie. I didn't do the screenplay. I didn't direct it. But like, if it's based on my book, you get to say who can do what with it. And also get who gets to translate it, whatever. Even who gets to distribute the copies. Who gets to perform works in public. So it could be musical or a play. If you wanted to do, make a show, Harry Potter the musical or something. You laugh now. I'm sure it's coming. I'm sure someone's working on it. Then, you know, after Glee, anything is possible, you know. And who gets to display works in public, for example, you know, pictures, things like that. So there's more to it than just the copying. There's also the derivative works. There's a very interesting concept in the US which does not apply in Ireland. One of the issues and one of the challenges that copyright poses in the internet age is that if you have different laws in the UK and Ireland and France and the US and Australia, and then you put stuff online, well, I mean, where does the jurisdiction lie? For example, the term of copyright was different in different countries. So there was a time when the copyright might have expired in some countries but not in others. So if you were in Canada, it would have been illegal to look at the work on the web, but if you were in the US, it would have been legal. If you have a website, like, how are you going to be navigating all that? You're going to say to people, I mean, I remember seeing, you know, websites, if you are in Canada or the UK, you know, do not click here. I mean, you know, what are you going to do? So that's another problem, that there are different jurisdictions. There was a time when you could say, well, my server is in Florida, so the laws of Florida apply. But now servers aren't even really in physical spaces even. You know, if you have a website, if you're hosting something on Amazon, in Amazon's cloud, or any of the other cloud services, and you say, well, where's my website physically? Well, what do you mean, like? You know, there's bits of it in Finland, there's bits of it in Florida. Depending on the time of day, we move some of it around, like. Could be anywhere. So, you know, which laws apply where poses huge problems for the web. In the EU, we've harmonized things somewhat. And then there are various trade tensions between the US and Europe, you know, where they don't agree on what things should be. So this fair use concept applies only in the US, but it's a very, very interesting one. And it's a very useful concept, because I think it captures some of the things that are reasonable. You know, that the copyright has limits. So, fair use allows an author or publisher to make limited use of a person's work for criticism, comment, reporting, teaching, scholarship, or research. So, if I wanted to discuss in class the writing style of J.K. Rowling in the third book, whichever one that is, it might be permissible for me to photocopy 1 or 2 pages and give them out to you so we could discuss that. If we were in the US. In Ireland, not so much. An interesting one is fair use for criticism or parody. So many of you may have seen clips from The Bunker. Is it called The Bunker, that Hitler movie? Where people have replaced the subtitles. Downfall, yeah. Where people have replaced the subtitles with topics relating to the day, the news of the day. So when the bank guarantee came out a few years ago, for example, there were versions of that floating around on the web where the subtitles reflected that. I think there was another very funny Ryanair one or something, where Michael O'Leary was Hitler and he was giving out. And I mean, the people who made that movie weren't particularly happy about that. I'm sure many Germans weren't at all happy about the trivialization of the Third Reich as well, but that's a totally separate issue. We won't go there. But the people that made that movie were saying, well, that's our movie. You can't be doing things like that. But in the US, something like that would be quite reasonable for the purposes of parody. So if you wanted to make fun of something, it may be necessary for you to use portions of it. So if I wanted to make fun of Eminem, I might, like he needs help making a fool of himself, I might be able to take samples and do something with them. And that would be considered acceptable because it would be a form of criticism or comment. So if you're in the US, there's this concept of fair use, which I think is quite useful. So the precise definition of it isn't set out, but courts consider the following. So the purpose and character of the use. So what are you doing? Is it genuine commentary or criticism? The nature of the copyrighted work. So, you know, is it a song? What is it? That's an impact. No. The amount and substantialness of the portion used. So if I want to make fun of Eminem, I mean, it probably wouldn't be acceptable for me to take 90% of a song and then, you know, take the mickey out of it in the last 10%. The portion of what's copied would be too great. But if I just take a little bit, that would be different. And then this is a useful one. The effect of the use on the potential market for the value of the copyrighted work. And that's important. Remember, the purpose of copyright was to ensure that authors get some benefit from their creative endeavors. So no one could argue, for example, that the re-subtitled Downfall clips would harm sales of the movie. There's a small portion of the movie, but also no one was going to say, well, I was going to buy that movie on Amazon, I was going to go see it in the cinema, but now that I've seen that YouTube clip with the funny subtitles, sure, I know what happens, I won't bother going. I mean, it wouldn't have an effect on the potential market or the value of the copyrighted work. At the same time then, there are moral rights too. I mean, if I have a photograph and, I mean, this has happened actually, someone in the US, there was two guys got married and their wedding photos were online, and some anti-gay group used the photo in their mail shots, you know, in their anti-gay literature. And the guys were like, well, you know, that was our photo. No, it certainly, I mean, even if all of this fair use might have applied, you know, you should have, there's the argument you should have some moral control as well over how your work is used.
Would that be counted as hate speech or anti-gay?
Possibly, but that was, I mean, that's a whole other, we're talking about copyright though, do you know what I mean? But I'm just saying from the copyright point of view, like, you should have some control over how your work is used as well. So there are some interesting issues there, but the fair use one, I think, is an attempt to deal with some of the things that we do with content. Like, I'm not saying it's very hard to have an original idea, because it's not. But like, we're so saturated with media that we're swimming in it. Do you know what I mean? And it's part of the environment. And like, if I'm an artist or a musician, I can't be expected to take my inspiration from the world around me just from the trees and the flowers and the sky and the sunrise, you know. I mean, that was fine for painters, you know, 200 or 300 years ago. I mean, the stuff going on the telly that I can't ignore, the stuff on the radio that I can't ignore. That's part of the landscape that we're in. And so artists have, you know, from kind of, well, from the start of the 20th century, have used that in their work. And if you take collage, for example, you know, we can look at some of that. But so it's an attempt to reconcile the fact that we do use some copyrighted material, but maybe to make new things or to do new things with it. And so that's an honest attempt, I think, to deal with that. So copyright is automatic, and the author has protection as soon as the work is created in tangible form. So as soon as you write your poem, that's got some copyright protection. Now, there are things you can do if there's some sort of a dispute. I mean, you hear people like posting things themselves, although I've heard that doesn't usually stand up in court, whatever, but there are places you can put stuff if you really want to. And although it varies from jurisdiction to jurisdiction, it has been standardized quite a bit now. Copyright lasts from 70 years after the author's death. And there's a problem there as well now that people have. Like, it was 50 years, it was even shorter. I think it's perfectly reasonable that if I quit lecturing to become a rapper, that after I stop, you know, if I stop doing concerts and stuff, if my songs are still on the radio, if people are still buying my CDs, I should be making some money from that. And it's reasonable that I should probably make that money as long as I live. It's also reasonable that maybe, you know, my kids could make a few bob from that. God knows, Daddy was on the road a lot, you know, didn't see him, you know, all those, you know, nights in hotel rooms. They make a few bob. But at 70 years, really, we're talking about my grandkids at this stage. And so some people say that's maybe too long. So that, I mean, J.K. Rowling is in fine health, so she's probably got another 30, 40 years in her. She's probably got longer than I have. So 70 years, until 70 years after she's dead, her kids and grandkids will be getting money from Harry Potter if people are still reading them, if they're still making money, which is very likely. No, I think she's, welcome to it. The question is for how long is her family welcome to it? So some people argue that 70 years is too long. Some things, some people died quite young. The guy who created Popeye, he died very young. So his 70 years is up now. So Popeye cartoons are no longer under copyright. In the US, there are things that people harshly, but perhaps fairly, call Mickey Mouse laws, because it seems like any time that the copyright term for Mickey Mouse is about to expire, they pass some new laws to make it last even longer, based on lobbying from Disney. So although Walt Disney's been dead quite a while now, I'm not sure how long he's dead though. But anyway, they keep extending it. Also, some things haven't come up. I mean, a movie, for example. Movies haven't been with us that long, I suppose. Maybe about 100 years now. I suppose slightly less than 100 years. But the stuff that's really, really old, who was the author? At what stage does the copyright in a movie expire? So there's some challenges and some questions we haven't really answered yet. Now, so cyber technology and the web, computers, various things, that can make protecting and enforcing your copyright very difficult. So as we know, computers can copy music and movies very easily, and networks can distribute them widely. And then there's the cross-border issues as well. I mean, if I'm sitting in Belfast sharing movies with people in Dublin, who are you going to call can be tricky. You're probably too young to remember Napster, but Napster was the first sort of music sharing, file sharing, peer-to-peer thing. Interestingly, Napster never actually copied the music itself. It's just if you had something you wanted and he had something to share and they matched, Napster put you together. And so Napster, when people were suing Napster, they made the point, well, what have we copied? Nothing. It's not like on our servers there's a load of music somewhere. It's not like Mega Upload or something, do you know what I mean? They never actually copied any music. So their argument is we're not doing anything wrong. And so after Napster, in a lot of places, laws were modified to make it an offense to enable people sharing. So it's easy, if you have a big server in a place that's known and you're giving movies away, they can come and shut you down. But if you're sharing a song with him and the next week you share that song with someone else and then he gets his song from someone else the next time, it can be harder to track you all down. But there are laws in most places now that make it an offense to enable that kind of sharing, even if you don't actually infringe the copyright yourself. Enabling others to do it is a problem. So the Digital Millennium Copyright Act then was a fairly controversial piece of legislation in the US. And it criminalizes the production and dissemination of technologies, devices, or services intended to circumvent measures that control access to copyrighted works. So you may have heard from the guy from Finland who couldn't get a DVD player for Linux to watch movies that he had in his DVDs. So he said, "I'll have to write one." So and he wrote code that would crack the encryption on DVD so that he could watch movies that he bought in the shop on his computer. And for a while he was like, criminal #1. I mean, he was being extradited to the US and all sorts of carry on. I mean, I think he's still in trouble. And that's because DVDs have encryption on them to make it harder to copy. The cat is somewhat out of the bag at this stage, but so to even write code that could do that was an offense under the Digital Millennium Copyright Act. College lecturers were a bit worried because it wasn't even clear if I gave you a lecture on that particular encryption technique and its various weaknesses and flaws and how you might crack it, would I be breaking the law and could I go to jail? It was also used for, it had sort of perhaps unintended side effects. The classic case in which it was used was a printer company. You know the way printer companies give you the printer for free nearly, and then they make their money off the ink. And then there were these companies where, these places, even one in Ballincollig, where you can go and they like squirt ink back into your cartridges for you so you can keep them going. Or you can buy generic cartridges for printers. Well, one company, and you can look it up, I might have a link to it, I think it was Lexmark, they decided then they were going to put chips on their printer cartridges, and the printer would talk to the cartridge and say, are you a genuine, Lexmark thingy cartridge? And it would say, yes, I am. And you'd say, well, here's this code, prove it, blah, 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 blah. And so there was like a handshake between the cartridge and the printer. And if it wasn't a genuine cartridge, it wouldn't print. You also get printer cartridges where if there's an expiry date on the ink and you don't use it, so you still have a full cartridge, but if the expiry date was up, it wouldn't print. Things like that. And so a company that makes generic cartridges looked at the software, looked at what was going on between the printer and the cartridges, and reversed engineered it so they could make generic cartridges that would work with those printers. And then Lexmark invoked the Digital Millennium Copyright Act and said, well, you have, produced technology that circumvents our access control. And so there's a big case. And I leave you to look it up and see who won and who lost. But I think most people would argue that making printer cartridges to work with printers isn't, some majorly criminal activity that's going to subvert the capitalist system. So the Digital Millennium Copyright Act criminalizes the act of circumventing the access control, whether or not there's actual copyright infringement itself. So if you write software to crack DVDs, you could be breaking the law. If you write software to get around some, digital rights management system, you could be breaking the law. And so it was a very interesting piece of legislation that some people say was rushed at the behest of Hollywood and has had some unintended side effects. So it's an interesting one to look up. So the Digital Millennium Copyright Act makes software for ripping DVDs illegal, for example, and publishing or even doing research on some kinds of encryption. So as a computer scientist, that's a big issue there, the bottom one. You know, if I do research on encryption algorithms, would I be breaking the law if I told anyone about it? Or is even doing the research, you know, against the law? It's interesting how, you know, Hollywood has had such a big influence on some of that legislation. So this is the printer cartridge case that I was telling you about, and I've given you the spoiler here. Lexmark eventually lost. Okay. And I'll put a link to that, some more information about that on the blog. It was a very interesting case. And there were very similar, you know, lots of similar examples. And so the court made the distinction between reverse engineering something to make it work with something else. You know, that was quite reasonable. It turns out the encryption, the handshake wasn't even terribly sophisticated. No. So what we might talk then about in the next class is the concept of making new works from old, and what's acceptable there and what's not. And for the blog this week, I just want you to think about the blogging and the privacy stuff, and I'll give you some very specific things to think about next week to do with intellectual property, to do with copyright. So you needn't go bother researching the copyright stuff this week. Save that for next week's entry, for your week 3 entry. Any questions on any of that? Okay. Thank you.